Which of the following would not be acceptable evidence of ownership? Deed signed by the last seller. Proof of ownership is evidence that title is marketable. A deed by itself is not considered sufficient evidence of ownership, even though a warranty deed conveys the grantor's interest. It contains no proof of the condition of the grantor's title at the time of the conveyance. What problems are not covered by either the standard of extended coverage title insurance policy, changes in land use brought about by zoning ordinances, not covered by either the standard or extended coverage policy, are defect of liens listed in the policy, defect known to the buyer, and changes in land use brought about by zoning ordinances. Standard coverage typically covers defect found in public record, forged document, incompetent grantors, incorrect marital statements, and improper delivery deed. An extended policy covers unrecorded right of persons in possession, examination of the survey, and unrecorded lien not known by the policyholder. Kate sells a portion of her property to Lily. Lily promptly records the deed in the appropriate county office. If Kate tried to sell the same portion of her property to Mike, which of the following statement is true? Mike has been given constructive notice of the prior sale because Lily promptly recorded her deed. Mortgage title policy protect which party against loss? Lenders. A mortgagee title policy, also called a lender's policy, is issued for the benefit of the mortgage company. That amount of the coverage depends on the amount of the mortgage loan. As the loan balance is reduced, the coverage decreases because only the lender's interest is insured. It is advisable for the owner to obtain a policy as well. A seller delivery a title to buyer at closing. Title search has disclosed no serious defect, and the title did not appear to be based on doubtful question of law or fact or exposed the buyer to possible litigation. The seller title did not appear to present a threat to the buyer's quiet enjoyment, and the title insurance policy provided was sufficient to convince a reasonable, well-informed person that the property could be resold. The title conveyed would commonly be referred as marketable title. Under the term of the typical real estate sales contract, the seller is required to deliver marketable title to the buyer at the closing. To be marketable, a title must disclose no serious defect and not depend on doubtful questions of law or fact to prove its validity. Not expose a purchaser to the hazard of litigation or threaten the quiet enjoyment of the property, and convince a reasonably well-informed and prudent purchaser acting on businesses principles and with knowledge of the fact of the legal significance that he or she could sell or mortgage the property at the later time. Which of the following is not covered by a standard title insurance policy? Unrecorded right of parties in possession. An extended policy is required if one wants to obtain the coverage. It protects the homeowner against defects that may be discovered by inspection of the property. Rights of parties in possessions, examination of a service, and certain unrecorded lien. When is the premium for title insurance paid? At closing. The premium of title insurance policy is paid once at closing and cover situations that have already happened. The maximum loss for which the company may be liable cannot exceed the face amount of the policy, unless the amount of the coverage has been extended by use of an inflation rider. What problems are not covered by neither the standard of extended coverage title insurance policy? Changes in land use brought about by zoning ordinances, not covered by either the standard or extended coverage policy, are defects and liens listed in the policy. Defect known to buyer and changes in lands use brought about by zoning ordinances. Standard coverage typically covers defect found in public record, forged document, incompetent grantor, incorrect marital statement, and improperly delivered deed. An extended policy covers unrecorded right of persons in possession, examination of the survey, and unrecorded lien not known by the policyholder. Which of the best type of, which is the best type of title? Insurable title. Title insured is considered the best defense of title. The title insurance company will defend any lawsuit based on an insurable defect and pay claim if the title are proved to be defective. A person who has searched the public record and inspected the property is said to have an actual notice. Actual notice means that not only is the information available, but someone has been given the information and actually knows it, such as an individual who has searched the public record and inspected it properly is said to have actual notice, also known as direct knowledge. If an individual can be proven to have had actual knowledge of information, he cannot use a lack of constructive knowledge, such as an unrecorded deed, to justify a claim. A purchaser went to the county building to check the recorder's record. We showed that the seller was the grantor in the last recorded deed, and that no mortgage was on record against the property. The purchaser may assume which of the following: the seller did not mortgage the property. Property recording a document in the public record serves as constructive notice to the world of an individual right or interest. So does the physical possession of a property, because the information or evidence is readily available to the world. A prospective purchaser or lender is responsible for discovering the interest.